You know, I do say it's, you know, I think, as I mentioned earlier, I think broader background experiences of the justices would be good. I think real experience in law practice is a deficiency. Too many professors on the court of both political parties, too many professors, many of whom I admire greatly, but I think a greater breadth of perspective. I would like to see more people who've served in the White House or in Congress, perhaps a former governor. All that would bring a different perspective to the court. You know, in some ways, the worst kind of politics is a politics that doesn't know it's a politics. And there's some sort of exaltation of, we're just deciding these issues mechanically, which some ways renders less transparent the grounds of decision. One of the reasons I admire Justice John Marshall Harlan II, I admired both the Harlans, but in particular I was thinking about the second Justice Harlan, because in cases involving the great claims of due process under the 14th Amendment, he really explained and talked about the considerations that he thought went into the decision, instead of acting as if it was all a mechanical matter and he was just adding it up on a calculator or an abacus and a result would come about. And I think that kind of candor about the process of decision making would be better. Well, I think the nomination process, there's a relationship between the nomination process and the kind of justices that we have on the court in terms of background, and I don't think it's altogether a good one. I think we have this model now of the professor, then judge, then justice. And therefore we have a model of a Supreme Court nomination process where we expect the nominee to be a law professor and to be able to answer 100 questions about standing and ripeness and what you think about this case and that line of cases. When, you know, if you took people who had great lives in the law, like the former U.S. senators or governors that used to be on the court, they wouldn't have, they're going to make up their decision about those matters when they get on the court. They wouldn't have any opinion about matters like that. Justice Black had been trying to save the country from the Great Depression when he went on the court. He wasn't into the nuances of technical doctrines. And I think I remember Senator Specter saying of one potential nominee, she's going to need a crash course in constitutional law. Her nomination was later withdrawn. But I thought, that's crazy. This shouldn't be an academic quiz on 100 cases. And it would be good to have a broader perspective on the court. Now, look, it's good to have some technically proficient justices on the court. It's not good to have 9. Because when you have 9 technically proficient justices, you're leaving out lots of other major experiences. Like Sandra O'Connor's experience being the first woman who was a majority leader of the Arizona State Senate. That's a vital kind of background perspective. Or Thurgood Marshall's experience having led the civil rights legal movement. Well, you know, in terms of how conversant one has to be with legal technicalities to be a justice, Hugo Black, and I wouldn't go this far, Hugo Black argued that he did not think that you needed to be a lawyer to be a Supreme Court justice. And he indeed offered up publicly the example of Walter Lippmann, a great political columnist of his day, that he thought would be a good justice. And he said to me after his interview that he thought Earl Warren had been a great Chief Justice, and Earl Warren didn't know anything about law when he got on the court. He'd been governor of California for several terms. He'd been his party's vice presidential nominee. You know, he hadn't been writing, you know, law review articles and or deciding cases as the Court of Appeals. There is a reason why no one on the court that decided Brown had any prior judicial experience. They were too important. You don't give up being the most important governor of California in a century in order to take a seat on the Ninth Circuit. You don't give up being the New Deal floor leader in the United States Senate to go on to the Fifth Circuit. So justices like Warren and Black that were there in '54 didn't have that. Now, Eisenhower correctly saw that there needed to be more balance on the court. That's why he named a state court judge like William Brennan. And that's why he named a highly skilled New York City practitioner like John Marshall Harlan. I think those were good additions to the courts. Potter Stewart had prior judicial experience. He changed that. But now that we're getting too close to the model of the professor, judge, justice exclusivity, and I think that's not necessarily the balance that the court needs. Well, it is said that cameras in the courtroom would change the dynamic, and I think that may not be all to the bad. That is to say, you would certainly not want to see lawyers showboating just because there are cameras there, but I don't think you would at the Supreme Court level. It would play very badly with any lawyer who had any sense. And I think sometimes the justices are unduly rude and abrupt and not comporting themselves with dignity, of making sarcastic remarks. And I think if cameras in the courtroom put some of the justices on a little better behavior, that quote, change in the dynamic of the court wouldn't be altogether a bad thing. Well, I think it would be useful for people to see the court at oral argument, and I think you gain a lot of understanding about what's going on at the court by watching oral argument. So yeah, I cannot think of any good reason. I mean, there's almost this notion that the justices are like demigods. Their office is literally a temple, modeled on a temple. I think there's an argument to be made that the building of that Supreme Courthouse in 1936-38 was a mistake. That, you go to work in a temple every day, you think you must be a god or goddess, and that's not a good attitude. When the court met in the basement of Congress, I think, now it didn't stop them from bringing on the Civil War and the Dred Scott decision, so it's not entirely an answer to judicial hubris. But the old courtroom was beautiful. It was in the Capitol building. And now that they have a temple, I don't like the message it sends to the justices when they go to work every day in a temple. Well, I think the Supreme Court, the journalists who cover the court are as good a group of journalists as you will ever see anywhere. I mean, it is an exceedingly difficult job to cover the complexity of oral argument, to get out those stories when massive decisions come down at the end of June. It's a journalistic corps that really respects one another, respects their fellow members of the press. I think generally the coverage is too judge-centric. That is, I've watched an advocate make an excellent argument and a justice be stupidly skeptical of it, and everybody writes it up that this was a failure on the part of the advocate rather than a failure on the part of the justices. There's always and of course they have the power, so that is, I see that as appropriate. But I do think that it would be good to have people be able to see more of the court's processes for themselves by having it televised. Now, I think popular understanding of the court, I don't want this to go to Tom Goldstein's head, but I have to say that Tom Goldstein is personally responsible for a significant enhancement of people's understanding of the Supreme Court and how it operates. I mean, SCOTUSblog has made the court much more accessible to people all out in the country, out in small towns who can get on SCOTUSblog.com, and much greater access to what goes on at the court than was ever before the case. Well, I'm not sure it's a great idea that the justices are out giving so many speeches and interviews. I may have played a role in getting this started. I interviewed Chief Justice Rehnquist at Duke, and then Justice O'Connor, Justice Ginsburg. I think I did the first public interview of Chief Justice Rehnquist. And I think now they proliferate, and every third day a justice is being interviewed or two justices are being interviewed. I think if the public wants to see more of the justices, they ought to see the oral arguments.